The Supreme Court recently denied a stay that would have protected a state's Second Amendment sanctuary law, but now that same case and issue is heading back to the Supreme Court next year. So let's talk about what is happening. Now, really quick before we jump into this video, I just want to wish everybody a Merry Christmas. I hope you and your family have amazing holiday season. I hope you guys enjoy your Christmas with your family. If you want to give me a free Christmas gift, consider subscribing, sharing this video around. All of that helps to, grow the channel. It does a lot to support the channel. But I just generally wanted to say Merry Christmas to you guys. Thank you guys so much for all the support you show to me and the channel. And again, I hope you guys enjoy your time with your family. As I mentioned in the intro, in this video, we're going to be talking about another significant Second Amendment case that is once again heading back to the Supreme Court, and the Supreme Court is going to be considering this next year. The case deals with a state's Second Amendment Preservation Act, and we've discussed this case prior because recently the Supreme Court issued an order denying a stay that would have protected the state of Missouri's Second Amendment Preservation Act. Now, after that denial order, this case was then sent back down to the 8th Circuit once again, who recently issued their decision in this case, and the 8th Circuit once again decided to side with the Biden administration and decided that the Missouri Second Amendment Preservation Act, or the SAPA law, is invalid because, in their opinion, a state law like this is invalidated by federal law because of the Supremacy Clause. Now, because of that decision in the 8th Circuit, this has now set up a very significant battle about a state's two-way sanctuary laws that is heading back to the Supreme Court for a final decision. Now, for those not familiar with what this case involves, back in 2021, Missouri passed the law here, which is the Second Amendment Preservation Act, or SAPA. The law set the state's interpretation of the Second Amendment and then also set restrictions on the support and funding that the state would provide to federal agencies and federal agents in their attempt to essentially enforce Second Amendment violation laws. So here the state said we are going to take away all the funding that we are giving federal agencies when they come into our state and are trying to violate the rights of residents when it comes to the Second Amendment. So a pretty based move here by the state of Missouri saying, no, we are not going to fund federal violations of the Second Amendment. Now, also what happened here in this specific law is that the state of Missouri then also said that the civil remedy here, or the lawsuits here that are going to be filed, are not going to be filed by the state of Missouri. So the state of Missouri, technically, through its officers and agents, don't actually enforce this law. Instead, it's the residents. So this law in the state of Missouri gave the power to the residents to file lawsuits against themselves, against state officials, if they violate this law. So if a state officer or agent gives funding or assists federal agents in violating the Second Amendment, well, then a private resident could sue that individual in Missouri and hold them accountable. Now, this Missouri law is similar in nature to the Texas abortion law known as SB 8 and also the recent Supreme Court decision in the whole women's health case. With the Texas and Missouri law, they're structured in a way to essentially prevent umbrella injunctions that would shut down the entire statute. And that's because, again, the Attorney General and the state and its officers and agents aren't the ones enforcing this law, it's the private individuals. In this Missouri case, the District Court on review ruled in favor of the Biden administration, striking down the Missouri Preservation Act in its entirety. Now, in response to that, the state of Missouri then appealed up to the 8th Circuit Court of Appeals. Missouri also asked for the 8th Circuit to place a stay on that lower court decision while this appeal was taking place. However, the 8th Circuit denied that request for the emergency stay. That then led Missouri, for the first time, to go to the Supreme Court on an emergency application. They wanted the Supreme Court to step in on an emergency basis and grant a stay against that lower court decision. But on review, the Supreme Court issued an 8-1 decision denying that request for the emergency stay. And the only one who was interested in actually granting that stay was Justice Thomas. So, prototypical Justice Thomas, he was the only one in favor of the Second Amendment. Now, after that Supreme Court 8-1 denial order, this case was then sent back down to the 8th Circuit for a final decision. They held expedited arguments in this case, and now they have issued their final decision. The 8th Circuit, in response, held expedited arguments and hearings in this case, and in the case, the state of Missouri made multiple arguments, including that the federal government does not have standing to actually bring this lawsuit and to sue the state of Missouri. The federal government is suing the state of Missouri and its attorney general, but like I mentioned, the statute only allows private individuals to enforce this law. Therefore, there is not a proper defendant in this case. They also went on to state during the arguments that the United States government cannot identify a single act by the state or its officers or agents that has actually harmed the federal government. Well, now we have a ruling by the 8th Circuit, and the 8th Circuit ruled once again in favor of the Biden administration. The 8th Circuit found that the SAPA law here is invalidated by federal laws. It's invalidated by the Supremacy Clause, and that the state of Missouri cannot have this type of statute. Based on that, the 8th Circuit panel upheld the lower court's motion for summary judgment and the decision which enjoined all of the SAPA law. Now, before we get too deep into the analysis, I do want to thank one of the main supporters of the channel, which is Brownells. Brownells is an amazing company. They support the channel here. They're huge friends of the Second Amendment. Their company does a lot to promote 2A causes. They donate a lot to 2A causes, so check them out. Again, I just wanted to mention that the channel is sponsored by Brownells. They do a ton for us here on the channel, so if you want to support a solid company that just does amazing things for the Second Amendment, go check them out. Now, in the decision, the 8th Circuit focused a lot on whether or not the federal government has standing to sue Missouri over the SAPA law. First, on the whole standing question, they looked at whether or not the federal government has suffered an injury because of this Missouri law. Like I mentioned, the state of Missouri said that the federal government has not suffered an injury, but the court here found that yes, the federal government has in some way suffered an injury. The 8th Circuit found that standing was met through the whole injury requirement, that there was an injury to the federal government because the lack of enforcement by the state of Missouri is in some ways, in the court's eyes, enforcement which caused an injury. They stated that to say that the United States was injured by the withdrawal of states' assistance is not to say that it is entitled to that assistance. Interference with the federal government's interest in enforcing federal law is sufficient to establish that the act's implementation injured the United States. Whether the United States is entitled to relief from that injury is a question on the merits of the dispute. So the 8th Circuit agrees that the federal government is not entitled to state help and they're not entitled to assistance, but then they also found on the same hand that the state pulling assistance is in fact an injury. The 8th Circuit then rejected the arguments that relief in this case would be insufficient since only private individuals can enforce this law. The 8th Circuit found that in some ways the state officials play a role in refraining from enforcing certain federal laws, and that refraining from action and the refraining from enforcement of certain laws is enforcement of certain laws. So essentially the 8th Circuit found that not acting on the law is acting on the law, and based on that they believed that there was standing for the federal government to sue the state of Missouri. And so the 8th Circuit upheld the motion for summary judgment and the general dismissal of this entire case. But now, here you have the state of Missouri, which has once again gone to the Supreme Court and is seeking Supreme Court final merits review of this case. Originally, the petition for Supreme Court cert would have been due in late November, but Missouri requested an extension based on the importance of this case, and then also the general workload of other cases that are going on right now, litigating, various student loan issues with the Biden administration, and then some of the general censorship lawsuits that are also going on. And the Supreme Court decided to grant the extension in this case. Now, with the general request for Supreme Court review, the state of Missouri is arguing that the 8th Circuit had concluded that the United States had standing to bring this lawsuit against the state, even though its governor, its attorney general, and all of those officers and agents aren't the ones enforcing this law, it's the private parties. They stated that this is the same threshold standing issue that the 5th Circuit rejected when the United States sued Texas over its abortion laws. This court granted cert in that case, but then dismissed the appeal without deciding that issue. They state that this case thus addresses 1, whether the United States has standing to enjoin a Missouri statute that is enforced only by private parties and only against local state political entities, not the United States. And 2, whether federal courts may second guess the reason states decide to exercise their authority under the 10th Amendment. So here, Missouri is hinting at the fact that the Missouri SAPA law case deals with a very similar issue that the Supreme Court found very intriguing prior and granted review in when it came to the Texas abortion law. They point out that this would be another case where the Supreme Court could finally address that issue, which prior they wanted to review and decide on, but then they decided on a different basis. So this is a very intriguing case. Once again, it deals with one of these similar issues that was granted review by the Supreme Court when it came to the Texas law. This deals with a state's Second Amendment sanctuary law, a state law which is trying to set a state's interpretation of the Second Amendment and protect their residents from federal actions which would violate the Second Amendment. It's going to be very interesting to see, how this plays out at the Supreme Court level. This is a final merits case dealing with a very controversial issue. So we're going to see how this plays out. But at the beginning of next year, we have another huge Second Amendment case that is going to be in front of the Supreme Court. So as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm and signal to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by ARM scholars, and this nation will be maintained by ARM scholars.